May I say it's a pleasure, Sir, Mr Hoyty, under your excellent chairmanship. The involvement of a parent in a child's life is nearly always a positive thing that will enhance the child's welfare, so long as the parent can be involved in a way that does not put the child or other parent at risk of suffering harm. And I would like to thank Women's Aid and the NSPCC for the attentive and tireless work they have done on the issue that we will be discussing today. And I would also like to make it clear that I generally see no problem with people who are in prison having a relationship with their children. In fact, I believe that contact is healthy and sustainable way to ensure the child is not affected by the enforced separation. However, when I see parental rights harming a child, I have to speak up. And what I'm going to talk about today is someone being able to control their child's life after they have committed the most obscene crimes on their own children. It cannot be right for a mother of a child who have been sexually abused by their own father that she has to fight for years just to change her children's last name, as they do not want to share the same name as their abuser. It cannot be right that she has to seek permission from that man who stole her children's childhood to take them abroad. When a person commits such horrendous crimes against their own children, they cannot be allowed to pull the strings from inside a prison cell. I have seen cases where a convicted child sex offender has the rights of a father and influences the lives of the children who were his victims. I have spoken to mothers whose husbands have abused their children, and I was left speechless and emotionally drained by their harrowing stories. They told me how the rights of their children to be free from their abuser are being ignored. And I would argue that these are rare occasions when the children are the victim of a parent, but the parent losing the right to be just that, a parent. If a child is taken into care as a result of a crime committed against them by the parent, then the state would assume responsibility of those children and parental rights would be removed from the offending parent. But when a parent abuses a child and the child stays in the custody of the other parent, then the offending parent is allowed to exercise parental control over those children. And even though access to his children will be limited, supervised or even banned, the convicted sex offender can still have a say over their upbringing. There is a fundamental flaw in the criminal justice system that allows this to happen, and it needs amending. When parental rights have a damaging effect on a child, they must be challenged. The hurdles parents are having to face just to protect their children and move on with a safe and happy life are unbelievable. We have heard of children that have been ordered to have contact with a parent who has committed offences against them, even though we know that in some cases children have been killed as a result of contact or residential arrangements. The decision is left to the family court to decide whether or not it would benefit the child for the abuser to have an input in the child's life. And the objective of the family court is to treat parents in exactly the same way and get cases over with rapidly. And that binds them to the consequences of unsafe child contact. And these consequences can be damaging and fatal. And that brings me to the topic of domestic violence and the impact that has on children. The routine granting of direct unsupervised contact, even when concerns about abuse are prevalent, reveals a pronounced lack of understanding about the effects of domestic violence on women and children. The point at which a survivor leaves an abusive partner is well recognised as a highly dangerous time for her and her children. Parental separation is often mistook as equating to an end of abuse and a reduction in risk for the mother and children, when in fact risks intensify. Around 1 in 5 children have been exposed to domestic violence, and 62% of children in households where domestic violence is happening are also being directly harmed. Children have been killed by violent fathers who have been allowed to see them through formal and informal child contact arrangements. Further avoidable child deaths must be prevented by putting children first in the family courts as the legal framework and guidance states. Only 10% of legal professions said that the judges fully complied with the judicial guidance for dealing with child contact cases where domestic violence is an issue. Most women want their children to have a relationship with a father, despite the violence they've experienced. They want to ensure that any contact would be physically and emotionally safe for them and their children. 45% of women experience violence after making a contact order, most commonly threats and harassment. The culture of contact with a child, no matter what, needs to be reviewed. Less than 1% of child contact applications are refused, but we know that domestic violence cases features in about 70% of cast caseloads and around 90% of cases going into the family courts. The system is failing children's safety and well-being, and the best interests of children should be the overriding principle of the family courts, but far too often this is simply not the case. So today I'm calling on the government to ensure that the family courts are putting the safety of children back at the heart of all decisions made by the family court judiciary. I welcome the revised version of the Practice Direction 12J adopted in October, setting out new requirements for judges, including that they explain why contact will not expose the child to further harm and how it is in the child's best interest. Practice Direction 12J requires the court to ensure that when domestic abuse has occurred, any child arrangements ordered protect the safety and well-being of the child and the parent with care and are in the best interest of the child. The revised practice direction is a critical step forward, but sadly, we know that all too often guidance in these cases is not followed, putting children's safety at risk. So it is critical that all judges, magistrates, court staff and CAFCAS officers know about this new guidance and how to use it. And I hope that this debate raises awareness about the new guidance and how important it is to ensure children's safety. Although the revised practice direction is a step forward and places new requirements on judges, there remain significant challenges with effective implementation. Training is critical to ensure that all judges, magistrates, all staff involved with this know about the new guidance and, more importantly, how to use it. Mandatory training for judges, magistrates and all staff on all aspects of abuse and coercive controlling behaviour should be part of a non-legislative package of measures. It should be face-to-face, delivered by specialists, supported by ongoing professional development, and cover the nature of coercive and controlling behaviour, the frequency and nature of post-separation abuse, and most importantly, the impact of the victims of the abuse. Training is vital to ensure judicial guidance is implemented and informs safe contact, arrangements for children in domestic cases and all abuse cases in the future. No child should have their life left in the hands of evil, and no child should be harmed in an act of revenge or rage to another parent. The impact of unsafe child contact can be devastating. I certainly will.
Mr. Rosey, it's nice to serve under your termship. I think for the first time, nice to see you in place. Can I just thank the honourable lady for bringing that forward? In her presentation that she's given to us so far, she hasn't mentioned the issue of parental rights of women in prison to have their children visited, and the importance that there is to have that in place, and the importance as well, if I could say, to a dedicated strategy for dealing with children's access to their parents and to their mother in prison. Because ever mindful in Northern Ireland we have 2/3 of the women of prisoners are women. Women inmates, and of those 9/10 of those have little or no access to their children. So just has the honourable lady given that consideration in her presentation this morning?
I certainly have, and I've just put a line through a large proportion of my speech because I totally agree with everything you've just said, and I am a great advocate I firmly believe that in a healthy situation it is vital for a child to have contact with a parent. But what I'm trying to highlight today is the case of very recently when I was contacted by a particular mum whose children were grotesquely abused by their father. A man who, in my opinion, does not deserve to be called their father. And I argue today that when someone is capable of stealing their own child's life through sexual manipulation, that their right to have a say on the future of that child should not mean dragging their mother to court at any given opportunity. That man should not be allowed to have any influence or impact on his children's lives, not just from the day he was convicted, but from the day he took their childhood away from them. There is urgent need for independent national oversight into the implementation of Practice Direction 12J. The government and senior leaders in the family courts and CAFCAS need to bring about a cultural change within the family court system to ensure that the safety and well-being of children and the non-abusive parents, i.e. the parent who's left to pick up the pieces after a terrible situation like this arises, is understood and constantly prioritised. That family, that mother, has every right to get on with her life, and the perpetrator of that crime needs to be removed from that situation. All members of the family court judiciary and CAFCAS should have specialist training to understand the dynamics of domestic and sexual abuse, and to be able to recognise coercive, controlling and the tactics used by abusive parents to manipulate their children's lives from inside prison walls. The Ministry of Justice must exert safety and risk assessments in child contact and particularly when there is an abusive parent involved. This should be dedicated to working with victims of abuse and a nationally recognised standard for responding to abuse cases. I would like to ask the government today, when will we see the implementation of, when will we see the draft domestic violence bill? As I would be interested to see whether we could amend that bill to ensure that this case and the case of not just one parent I spoke to, but one parent I talked to you about today, whose life has been destroyed by a man inside a prison cell who still tries to control the life of her children, who still tries to control the life of her children. So I thank the Minister for listening and hope that we can work together to try and find some kind of solution that works for all, but certainly brings some peace of mind to those children and mothers or fathers who have been involved in this terrible, terrible crime.
Honourable Member for her intervention. If she will allow me, I will develop my argument with regards to the current powers of courts in such cases. But as I was saying, the Honourable Member for Swansea East is fast developing a strong reputation for campaigning on sensitive, difficult, often family issues, and I commend her for her work in lots of different areas. I am here this morning on behalf of the Minister of State for Justice, who is detained with legislative business. While policy responsibility for family law sits with him, I have listened carefully to the points made this morning and will ensure they are relayed to him in full. It is clear that significant distress and emotional harm can result when a parent is in prison, exercises their parental responsibility with the clear intention of frustrating day-to-day care decisions made by the other parent or to inflict further harm. Such behaviour is unacceptable. While the maintenance of family ties forms a key foundation stone to support an offender's rehabilitation, it is clear that not all children can or should maintain contact with a parent who is in prison. Maintaining family ties must always be balanced against the risk of harm posed to the child or parent with care. While there are a number of protections already in place under the current law, particular issues arise in cases where children are the victims of an offence by the convicted parent. I have listened very closely to the points made about the practical impacts of parental responsibility when exercised in this way, and the arguments for a change in the law so that a parent prisoner convicted of a sexual or violent offence loses their parental responsibility upon conviction. In considering the arguments for change, I would like to set out the current law. There are various aspects to the law on parental responsibility: how parental responsibility is acquired by a parent, whether and how parental responsibility can be removed from a parent in appropriate cases to protect a child or the other parent from the risk of further abuse or harm, and the exercise of parental responsibility by a parent and the means by which a court may restrict the exercise of parental responsibility in specific ways. Mothers automatically acquire parental responsibility. A father who is married to the mother at the time of the child's birth also acquires that responsibility. There are no provisions in current law by which parental responsibility may be removed from a mother or married father except through adoption of the child. Unmarried fathers may acquire parental responsibility through various means: birth registration, an agreement with the mother which is registered with the court, or by court order. A court may remove parental responsibility from an unmarried father if the child's welfare so requires. Where a parent seeks to abuse their parental responsibility, their actions may be overridden by the family court. This power applies regardless of how that parent acquired parental responsibility. The child's welfare is always the paramount consideration, and there is no absolute right for a parent or any other person to exercise parental responsibility in a way that is detrimental to the child's best interests. That is clearly the right position in principle. The ability of a parent prisoner to exercise parental responsibility in many aspects of a child's day-to-day life is limited by having no direct contact with the child or the parent with care, and there are powers available to the family court to restrict the exercise of parental responsibility, which I will talk about in a moment. However, where those protections have not been sought or have not worked for whatever reason, a parent who is determined to abuse their parental responsibility may still be able to do so. Where there is disagreement between parents who each have parental responsibility, either of them may make an application to the family court for a prohibited steps or specific issue order. A prohibited steps order has the effect of preventing a parent exercising his or her parental responsibility for their child in a specified way, without first obtaining the consent of the court. For example, changing or causing a child to be known by a different surname. A specific issue order allows the court to determine how a specific aspect of parental responsibility for a child should be decided. For example, whether a child should change school. In addition, and where the court is making any order and the person who has applied for it has made multiple previous applications in relation to that child which the court considers to be vexatious in nature, it may make an order restricting that person's ability to make any further applications of a specified kind in respect of that child without the permission of the court. I recognise that these current protections place the onus on the parent with care to apply to the family court to restrict the other parent's exercise of parental responsibility, and that is why there are calls to legislate for an automatic removal of parental responsibility in certain circumstances. Questions have been raised about the effectiveness of these orders and how they can be best used to protect a child or parent with care from the abusive exercise of parental responsibility by a parent in prison. Any change to remove parental responsibility automatically on conviction of certain criminal offences would involve some important considerations for my department. We would need to be clear that such a change in the law would be in the best interests of all children for whom the current law provides maximum flexibility. The family court currently balances the legal rights, responsibilities and duties of each parent with the paramount need to further the welfare of the child and to safeguard them from risk of harm or further harm. Of course.
To consider a change in the law which created a rebuttable presumption of the loss of parental responsibility in certain circumstances, which would put the onus then not on the parent with care, but the parent who's perpetrated the damage.
I certainly think that warrants consideration, so I will take that away and pass it on to my ministerial colleague. Legislation to remove parental responsibility upon conviction of specified offences would need to be carefully considered given the potential to impact on a wide range of children in different family circumstances. There would be many points of detail to work through, some potentially quite difficult. In order to ensure that any changes to the law were workable in practice and would be likely to achieve the desired outcome while maintaining the right balance between rights, duties and responsibilities and protecting vulnerable children and adults. Now I'll turn to some of the questions that have been raised in this interesting debate. Firstly, to the member for Swansea East, she made reference to judicial awareness of Practice Direction 12J and mandatory training of judges. The Judicial College plays a vitally important role in providing the appropriate training to all family judges. The President of the Family Division has publicly urged the judiciary to familiarise themselves with the new rules and to do everything possible to ensure it is properly complied with on every occasion. She also asked about fathers exercising parental responsibility and why should they have the right to control a child's life behind bars, and indeed the member for Gower has also asked that question. The Children Act 1989 makes clear that parental responsibility can be exercised alone unless the law requires the consent of all of those who share parental responsibility. Courts have held that there are exceptional categories of decision needing such consent. For example, changing names, taking the child abroad, etc. Day-to-day decisions should not be affected or blocked by the father. The member for Stretford and Urmston's, who characteristically made an informed speech this morning, mentioned recognising the importance of children having contact with mothers in prison. Prisoners have a statutory right to have contact with their children where it is safe to do so. There is a presumption that a parent's involvement will further the child's welfare, and this is not revoked or rebutted where a mother is imprisoned, provided contact remains safe and in the best interests of the child. She also asked about sentencing of mothers without consideration of impact on dependent children. The courts are already required under Article 8 of the European Convention on Human Rights to obtain information on dependent children and conduct a balancing exercise, weighing the rights of potentially affected children against the seriousness of the parent's offence. Case law shows this is often done in practice. The government cannot interfere with the exercise of the judiciary. She also raised the charity Visiting Mum, a programme run at Eastwood Park, funded by, I gather, the Big Lottery Fund. It has supported 150 children and 89 mothers to have visits from Wales to Eastwood Park in Gloucestershire. I can assure her that its work is being considered as part of the broader women's justice strategy. My honourable friend, the member for St Ives, spoke of the improving situation for women offenders and family access. As I've just said, we are developing a women's strategy which will be published in the new year to improve outcomes for women. There is a legacy of where prisons are, which makes it practically difficult to hold women closer to home. The Shadow Minister made reference to new custodial estate being absent, women's custodial estate in Wales. I can assure you I've not met anybody who wants a prison to be built for women in Wales. Let's just say that all of the decisions around women's justice are currently under consideration, and that I would hope that all colleagues, particularly the member for Stretford, will be pleased when the strategy is published in the new year. In closing, I of course cannot make any commitments today about changing the law on parental responsibility, but the government will give careful consideration to the points raised in debate this morning. I do thank the Honourable Lady for securing this debate and for raising these important issues.
Sum up.
I'd like to thank all colleagues for attending today and for very many excellent contributions. And I want to pay a special tribute to my honourable friend for Gower, without whom support and bringing my attention to this very dreadful case in particular, we wouldn't be standing here today. It's not a comfortable position for me to be standing here and not ranting about improving prisoners' rights and access and parental rights. Ranting is probably what I do best, but on this occasion I am deeply, deeply concerned that a family is being torn apart by one person whose controlling behaviour to his victims is allowing him to have any control whatsoever, not just now but in the future. And I know that the Minister is a compassionate man. I know we've spent many hours discussing other issues, and I know that he will work with me and my honourable friend from Gower and try to find a way through this which will bring some solution to those affected by this dreadful situation. Thank you, Mr Horsey.
The question is that the House has considered the parental rights of prisoners. As many of that opinion say aye. On the contrary, no. The ayes have it, the ayes have it. Order, order. We'll suspend the sitting until 11 a.m.